This is Based in Fact, a true crime podcast. Join host Lisa O'Brien as she examines America's most infamous true crime cases through the lens of the court, not the court of public opinion. No spin, no theories, no rumors, just facts. Here's Lisa O'Brien.
In episode 18, Kyle and I are talking about State of Oklahoma versus John Fitzgerald Hanson. Hanson was facing execution on December 15th, 2022 for the 1999 murder of Mary Bowles. Hanson and his partner Victor Miller kidnapped Mary from a Tulsa mall on August 31st, 1999. They brought her to a dirt pit in Owasso where they encountered the owner, Jerald Thurman. Miller shot Thurman, then Hanson took Mary from the car and shot her to death as she lay in a ditch. We'll talk about the case against Hanson, his trial, direct appeal, resentencing trial, second direct appeal, post-conviction claims, and his life sentence in federal prison. In keeping with the current administration's stance against the death penalty, Bureau of Prison officials denied Oklahoma's transfer request. The federal officials' decision to act outside their legal authority has prevented the state of Oklahoma from carrying out Hanson's lawfully imposed sentence. And we'll talk a little bit more about that toward the end of the show. Good afternoon, Kyle. How are you?
I'm doing okay. Good afternoon, Lisa. How are you?
Pretty good. I am getting ready for Thanksgiving. Looking forward to it.
Yeah, absolutely. And we've had a cold snap here. We went from like 65 to 35 in a day. So my body is still getting used to the newly entered winter weather.
Yeah, ours went down to 45 today, this morning when I got up, and I had to turn the heater up, but I'm having hot flashes. So the heater is problematic. Because I have to go and turn it completely off, and then all of a sudden I'm cold. So this winter is going to be unpleasant.
No, you're going to have a fun time. It's going to be interesting.
Yeah, it's going to be very interesting. And so life is just busy, and we missed. I hurt my back, and so we missed recording on Halloween weekend. And but we're finally back today. Yay!
Yeah, I'm looking forward to it.
So, all right. Well, let's start off Hanson, and just to let you know, we're not going to talk about Victor Miller, who was Hanson's accomplice, co-defendant. Miller was tried separately, and he was also sentenced to death, but his sentence was eventually the court commuted one death sentence, and the Tulsa officials, given that they had tried sentencing him to death twice and had not succeeded, after consulting with the families, had eventually determined that they weren't going to try and sentence him to death again. So that's a totally different ball of wax, and it's a complicated history that I did not feel would be served well trying to go over this with Hanson, with everything going on with his case. So we may talk about Miller at another time, and we may not. The victims in this case, there are two victims. The first was Mary Agnes Bowles. She was born November 14th, 1921 in Turley, which is in Tulsa County, Oklahoma. Her father was Arthur Garfield Bowles, who died in 1949. Her mother was Mary C. Camp Bowles, she died in 1970. So at the time of Mary's death, she and her sister Ora Lee Bowles Parker were the only surviving members of her small family. Ora died in 2008. Ora was the younger sister. Mary was the older sister. Mary was educated at Central High in Tulsa. She also attended Tulsa University and eventually graduated from Oklahoma A&M in 1943. She went into banking and worked her way up, retiring in 1989 as the senior vice president at the Bank of Oklahoma. She was a member of the First Christian Church. She was also on the board of that church. She did volunteer work with Tulsa Philharmonic, St. Francis Hospital, the Tulsa Speech and Hearing Center, Board Quota International of Tulsa, and the Child Development Center at First Christian Church. Her injuries and cause of death were multiple gunshot wounds.
Yeah, and it's interesting, just coincidentally, tomorrow would have been her 101st birthday.
Correct. Exactly. Yeah, she would have
And
turned 100 last year.
She deserves a lot. I mean, a lot of credit. It's very impressive if you think about it, for a woman in 1999 to be a senior vice president.
1989.
89.
1989.
I mean, you talk about a woman who busted through a lot of glass ceilings.
Mm-hmm. Correct. And she was, as best I can tell, she never married. She never had children, but she was very close with her sister. And her death had an impact on her sister's life. She was also close with her niece and Ora's family.
And if those of you that are wondering, Oklahoma A&M, today we know it as Oklahoma State in Stillwater, Oklahoma.
Mm-hmm. And also, I mean, the charity work that she did after she retired, she stayed very active. And
yeah, she sounds like a remarkable woman.
Was a very active, even though she was in her 70s. By this time, she was 78. She or soon to be 77. She was soon to be 78. The second victim in the case is Jerald Max Thurman. And Jerald, it's an unusual spelling. It's Jerald. I had a boss whose middle name was spelled that way. And that was because the midwife who delivered his father, because he was a junior, did not know how to spell. And that was like his father was delivered at home birth by a midwife. And when they gave the name Jerald for his middle name, she didn't know how to spell it. So she spelled it Jerald instead of Gerald. His father, he was born May 16th, either May 16, 1954 or May 16, 1955. There are alternate birth years for him on various sources out there. His father was Lloyd Max Thurman, who was born November 15th, 1932, and will be celebrating his 90th birthday, because as far as I can tell, Mr. Thurman is still alive. I don't know who Jerald's mother was, but his stepmother was Betty Hebe Henry, who was born January 31st, 1943. He had sisters Linda, born in 1951. She died in 2002. And then Patricia and Charles, born in 1964 and 1968. He was married to Sherry and at the time of his death, and had a son, Jacob. Jacob, I would imagine, is an adult at this time. I don't have a birth year for Jacob, but he was a child, as far as I can tell, in 1999 when his dad was killed. Jerald was a business owner in Owasso, Oklahoma. He owned, alternately, it says he owned a trucking company, and it also says he owned the dirt pit where events occurred in the case. He also died from multiple gunshot wounds. Or his injuries caused the death with multiple gunshot wounds. Our perpetrator is John Fitzgerald Hanson, who's also known as George John Hanson, who's also known as John Hanson, who's also known as John, spelled Jon, Fitzgerald Hanson. His date of birth is April 8th, 1964.
Possibly named after President Kennedy?
Potentially named, probably was named John Fitzgerald after President Kennedy. You're right. But that is where the similarities ended. His grandmother was named Joyce Leake. His mother was Charlotte Ward. He had an older brother, Stephen Hanson. He had a sister named Sharman Clariot, younger sister, cousin Marcia Hollingsworth, and then a girlfriend or an ex-girlfriend at the time of the murders named Ladosha Warrior, and she was the mother of Hanson's son. I did not find any information about his son, such as a name, etc. And he was a very young child at the time of events. And so I think it's better that his son's name is not a part
Yeah,
of this
absolutely.
discussion.
He doesn't need to carry that around with him.
Fitzgerald Hanson has quite an extensive criminal record. He was convicted of first-degree robbery in 1982. He was convicted of first-degree, also a separate first-degree robbery and assault with a deadly weapon, also 1982. He was convicted of escape in 1990. He and Victor Miller were committing robberies in 1999, and they also, after committing the murders of Jerald Thurman and Mary Agnes Bowles, they committed a bank robbery, a federal bank robbery, within days of these murders. The victims, of course, were Jerald Max Thurman and Mary Agnes Bowles. And currently, Hanson is sentenced to life plus 107 years, alternatively reported as 1,500 months or 1,800 months. And he is incarcerated at USP Pollock in Pollock, Grant Parish, Louisiana. That is going to present a problem later in our story.
Yeah, that's an obvious question that jumps out that I know you're going to get to, but that was my first big question was, wait, I don't understand.
And I will say this, I don't know why. He was transferred from Pollock for trial. He was transferred from the federal prison system for trial. He was for the capital murder trial in Oklahoma. He was transferred for his resentencing trial in Oklahoma. I don't know why Oklahoma sent him back to the feds after he was convicted of capital murder, especially after the resentencing. I don't understand
exactly.
that. I would have been happier had they kept him. But they did send him back to the federal prison system to serve his federal bank robbery and weapons possession charges. The crime in this case occurred on August 31st, 1999. The victims were Mary Agnes Bowles, who was 77. She died on, she's reported as having died on September 7th, 1999. It's more likely than not that she died on August 31st. However, in Oklahoma, her date of death becomes the date her body was found. And then Jerald Max Thurman, who was 44 or 45, he died on September 14th, 1999. And he did die in a hospital after never regaining consciousness as a result of his gunshot wounds. The summary, what happened was on prior to August 31st, Hanson and Victor Miller were committing a series of armed robberies in the Tulsa area. Because they needed a vehicle to continue their spree, they carjacked and kidnapped Mary Bowles from the Promenade Mall, where she was walking for her health in Tulsa. She had gone to the mall for a walk after volunteering at St. Francis Hospital that day. While Miller drove, Hanson held Miss Bowles down in the back seat. Miller drove to an isolated area in Owasso, entering the road leading to a dirt pit where the pit's owner, Jerald Thurman, was loading a dump truck for delivery. Jerald was on the phone with his nephew at the time and reported to his nephew that he had seen a strange car circling the pit. When Jerald finished his call, he left the pit, intending to lock the gate with the vehicle still in the pit area. Miller and Hanson have claimed that they were at the pit to release Miss Bowles.
You know, Lisa, though, back to the original crime, it doesn't make any sense. If you just need a car, there was no reason to take Miss Bowles with you. Why did they not just leave her at the mall? Like, that's where I have a hard time buying their excuse, because if they just needed a vehicle, she wasn't in the vehicle. There was no reason they couldn't have taken her out and
Well,
just taken the car.
it's potentially what happened is they saw her coming to the vehicle and they carjacked her.
Right, but they
with the
still could have let
keys.
her out at the mall. They didn't need to take her with them.
I agree in a sense, I agree, but I think what happened was if they left her at the mall, she goes in, she reports the car, she gives a description of the car, police have that description, they're going to immediately be picked up. Whereas if they carjack her and take her with them, they have use of the car without anybody knowing that it's been stolen. And I think that was their intent.
Okay, maybe
To-
maybe you assume better intent than me, but fair enough.
Because she would have gone in the mall and reported it stolen, and I think their actions at the pit contradict their claim that they were going to release her unharmed, because they immediately drive out. Miller gets out of the car and shoots Jerald, leaving him by his truck, mortally wounded. And then they drive a short distance away, and Miller tells Hanson, you know what you have to do, because she's witnessed Jerald Thurman's murder, and stopped the car in an overgrown roadside ditch. Hanson took Miss Bowles out of the car and used his own 9mm semi-automatic pistol to shoot her 4 to 6 times. Miller and Hanson then covered Miss Bowles' body with branches and left in her car. Her body was found on September 7, 1999. Neighbors, after hearing gunshots coming from the pit area, observed a strange car drive by, and shortly after found Jerald lying next to his truck. He was transported to a hospital where he died on September 14th without regaining consciousness. So they had the car. They didn't have anybody who was going to report it missing or report it stolen to police. So they had unfettered use of the car with the keys by carjacking and kidnapping Ms. Bowles. Again, I don't believe that they intended to release her unharmed or any of that stuff. I think they tried to lessen their intent to try to lessen the crime by, making it look like, well, they just had to, and they probably, had to kill Jerald because he was going to lock him in the pit.
Yeah, I mean, I don't know. I know we could play the what if game, but I just think about, this is 1999. There's no mobile phones. Even if they dropped her off at the edge of the mall, she was what? I forget, 74. By the time she walked to the mall, found a payphone, it's probably 15 or 20 minutes before the police are notified and looking. They would have been home by the time anybody got to the phone. That's why I'm a little bit suspicious of why they kidnapped her.
But Jerald Thurman apparently did have a mobile phone because he was on the phone with his nephew.
It was fair, yeah. It wasn't super common. Yeah, some people had them, but
it wasn't as
like
common as it is
had
today.
one.
But
yeah,
right. But had they, again, as I said, had they left Mary Bowles at the mall, she would have immediately gone into security. Police would have been called, and there would have been a description of her stolen vehicle on the airwaves in Tulsa within minutes. Whereas kidnapping her and even bringing her to the pit would have delayed that car being reported missing or stolen. At any rate, Hanson and Miller then drove Miss Bowles' car to the Oasis Motel, where it broke down on them. They borrowed tools in an effort to get the car running again, and were observed working on the car by the motel clerk. When they were unable to get the car started, Hanson rented a room in the motel using his own name and presenting his driver's license to the desk clerk. Hanson and Miller then left the Oasis Motel and never returned. On September 3rd, they robbed a liquor store, and on September 8th, they robbed a credit union. Miller's wife, for at least the credit union, acted as their getaway driver. Miss Bowles's body had been found on September 7th, and on September 9th, a patrol officer found her car at the Oasis Motel. Fingerprints from Miller and Hanson were found on seatbelts in the car. And by this time, Hanson and Miller were staying in an O'Connell Lodge in Muskogee. Also on September 9th, after Miller threatened her life, his wife turned them both in. Miller surrendered shortly after law enforcement arrived at the motel. Hanson held off, attempting to hide the guns and ammunition in the room's toilet tank, where they were found after he eventually was driven out of the room by tear gas and he was arrested. Once in custody, Hanson confessed to carjacking and kidnapping Miss Bowles, described how Miller killed Jerald Thurman, and confessed to Mary's murder. A few days before his arrest, Hanson had also made incriminating statements to a friend, Rashad Barnes. Hanson stopped by Barnes's home and confessed that he and Miller carjacked an old lady and that he had killed her. Hanson, that is. So they were arrested on September 9th, 1999 at the O'Connell Lodge in Muskogee, Oklahoma by several agencies, likely Tulsa police, as well as federal authorities. Hanson was indicted on first-degree murder of Mary Bowles in count 1 and first-degree murder of Jerald Thurman in count 2, and each count was charged alternatively as malice or felony murder. The venue was Tulsa County, Oklahoma. Now, in 2000, the Miller and Hanson went to trial for the bank robbery at the Tulsa Credit Union. That's a federal offense in the U.S. District Court for the Northern District of Oklahoma. The case numbers were 99 CR 12501 and 12502. They were found guilty in January of 2000 of armed robbery. They were also found guilty of weapons charges. Hanson was sentenced on June 28, 2000 to life plus, it's been reported as 1,584 months, but it's also been reported as 1,800 months. So his federal sentence is not going to end until he dies. The sentence and convictions and sentences were affirmed on July 26, 2001 by the 10th Circuit Court of Appeal, and the U.S. Supreme Court denied petition for cert on October 1st, 2001. So those convictions and sentences became final. And interestingly enough, I don't find any evidence that either Miller or Hanson pursued post-conviction claims in federal court from these convictions or sentences.
Do you think that could have been because they knew they wouldn't face the death penalty? And you think they were thinking, if I can just stay in the federal pen, I'll avoid the death penalty?
I don't know. I guess, or perhaps it's because the state convictions and the state claims were stronger or potentially stronger. But I don't know, but it was interesting that they didn't have, competing post-conviction claims going, and their time to do so has long since passed. So those federal convictions are basically unassailable now. So Hanson's first state trial, he was represented by Jack E. Gordon Jr. and Eric Stahl. The state was represented by an attorney with the district attorney's office named Tim Harris. Venue, of course, was in Tulsa County District Court. The judge was Honorable Linda G. Morrissey. The guilt-innocence phase of Hanson's trial, Victor Miller and Hanson were charged together, but their cases were severed for trial. So Hanson was tried independent of Miller. His guilt and innocence phase was May 7th, 2001 to May 22nd, 2001. He was found guilty of the first-degree malice murder of Mary Bowles in count 1 and the first-degree felony murder of Jerald Thurman in count 2. The penalty phase began on May 22nd, 2001, and concluded on May 23rd, 2001. The aggravators charged were previous felony convictions, great risk of death to more than one person, murder committed to avoid, prevent arrest, and future dangerousness. The aggravators found by the jury were previous felony conviction, great risk of death to more than one person, and future dangerousness. And the jury sentenced Hanson to death on count 1 and life on count 2. His sentence was formally entered on June 8, 2001, and that was death on count 1 for the murder of Mary Bowles and life on count 2 for the murder of Jerald Thurman, and his execution was set for August 14, 2001. His case proceeded to direct appeal. At that time, OIDS came in. The attorneys were James Lockard and Jamie Pybos. The state was represented by the Attorney General's office and David Brockman. The issues, I'm not going to go into all the issues raised on his direct appeal because he was successful on issues related to jury selection, and his death sentence was reversed as a result of those issues. And so it's not really necessary. His conviction and his life sentence were both affirmed, but his death sentence was reversed. So we're just going to talk about the issues raised regarding jury selection. And that was that Hanson was denied his right to a full and fair examination of prospective jurors' views on automatic imposition of the death penalty for malice murder when the trial court repeatedly denied Hanson's requests to life qualify the jury by asking whether jurors would automatically impose the death penalty for first-degree murder. That was Proposition 6. In Proposition 7, Hanson claimed that a juror named Fulfaro should have been excused for cause because when questioned by defense counsel, Fulfaro said he believed that defendants had their day in court, but victims' rights were forgotten. He said he believed in an eye for an eye and approved of the strict punishments found in Middle Eastern countries. They argued that the failure to remove this juror for cause prejudiced Hanson, and in combination with other errors, it required that count 1 be remanded for resentencing. The court issued an order. This was his notice of intent to appeal, and the issues he was raising were filed on June 8, 2001. An order issued on July 12, 2001, granting a stay of his August 14th execution. The decision of the appellate court was entered on June 11th, 2003, and basically found that on review, defendant argued that the accumulation of errors at trial deprived him of a reliable sentencing proceeding. The Court of Criminal Appeals agreed, finding that defendant was not allowed to discover whether potential jurors, including sitting jurors, would automatically impose the death penalty for malice murder. When the trial court refused to accuse just such a biased juror, defendant used a peremptory challenge to remove him and was forced to keep an unacceptable juror on the panel. The Supreme Court, which is the Court of Criminal Appeals in this case, could not determine whether defendant should have been allowed to present his expert witness to present risk assessment evidence and rebut the state's allegation that he would be a continuing threat to society. As the jury was not instructed on the elements of the continuing threat aggravating circumstance, the instructions also failed to properly guide the jury's discretion. The jury did not hear defendant's requested instruction on mitigating circumstances, which were supported by the evidence and were the focus of his case in mitigation. The jury heard improper victim impact evidence, and the Supreme Court did not find any of these errors were harmless beyond a reasonable doubt. So that's why they reversed the sentence of death and ordered a resentencing. So the convictions and the life sentence were affirmed. The resentencing trial, at that trial, he was represented by Jack E. Gordon Jr. and Stephen M. Hightower. And the Tulsa DA, William Mussman, came in. once again, it was in the district court for Tulsa County, and the judge at that time was the Honorable Caroline Wall.
So just out of curiosity, all these appeals, are these usually just done pro bono by different groups? I mean, I think about, who's paying for Gordon and Hightower? Are they?
Yeah. It doesn't indicate that they're with OIDS. They are more likely than not paid by the county of Tulsa in some way, shape, or form. I'm not familiar with Tulsa's indigent defense systems. I know they have the Oklahoma Indigent Defense Service, and then they also have public defenders. I think they also have private attorneys who also take appointment as indigent defense attorneys. But the intricacies of that system are better left to an expert like Shelley Levisay, who is the Oklahoma attorney who hosts Lawyers, Guns, and Money podcast. Frequently dealing with
great
Oklahoma.
Warren Zevon callback, by the way. What a great song.
Yes, it is. So, and that may be something down the road to talk about how the Oklahoma defense system works, because it is interesting that in some of these cases, it's appeared that these defendants were being represented in the trial by private attorneys, and then their appeals were being handled by a public defender or an indigent defense system attorney. And that has kind of boggled my mind occasionally. And I think we talked about that with Colt.
Yeah,
because it appeared that he was being represented by private attorneys all along.
Well, I do know if I ever have to call you unexpectedly, it will be to send Lawyers, Guns, and Money.
Yes. So that may be a show down the road. Also, while the resentencing trial was in the pretrial stages, on January 14, 2005, Hanson filed an application for post-conviction relief in the trial court, seeking a new trial based on the allegation that Victor Miller had confessed to Mary Bowles' murder during his testimony at his trial. He also, at his trial, tried to claim that it was Hanson and Rashad Barnes who committed the murders. There was a hearing held on March 2nd, 2005, at which time the trial court granted Hanson's request for post-conviction relief. And that order entered on March 14th, 2005. But the judgment was stayed pending the state's appeal to the Court of Criminal Appeals. On June 3rd, 2005, the Court of Criminal Appeals denied Hanson's motion for a new trial and post-conviction relief, finding that the district court did not have jurisdiction to adjudicate Hanson's post-conviction application because the Oklahoma Court of Criminal Appeals alone has the power to consider post-conviction applications in capital cases. The district court's order granting Hanson a new trial was vacated, and the matter was remanded to the district court to conduct the resentencing trial. That took place between January 9th, 2006 and January 24th, 2006. The state offered 3 aggravating circumstances: previous felony conviction, great risk of death to more than one person, and that the murder was committed to avoid or prevent arrest. On January 24th, 2006, the jury reached its verdict. They found the 3 aggravating circumstances offered by the state, and they sentenced Hanson to death. That formal sentencing occurred on February 7th, 2006, at which time Judge Wall set Hanson's execution for May 9th, 2006. Hanson filed his notice of intent to appeal that day, and the Oklahoma Indigent Defense System was appointed to represent him. And just to kind of, as an aside, sort of, what happens in Oklahoma is they will appoint different attorneys to represent a defendant on appeal, because their post-conviction claims, certain claims have to be raised on direct appeal, and ineffective assistance of trial counsel is one of them. So they appoint different attorneys to ensure that if there is ineffective trial counsel, that is brought in on direct appeal, or timely brought in during direct appeal.
Yeah, and we've said before, if you have Johnny Cochran and F. Lee Bailey representing you, you'll still appeal on ineffectual counsel, because that's just like a standard.
Correct.
You could have William Jennings Bryan and they would still claim ineffective counsel.
Correct. So the attorneys, Jamie Pybos returned as direct appeal attorney for Hanson, and Kathleen Smith, also with OIDS, was appointed, and the AG's office through Robert Whitaker came in to represent the state. An application for stay of execution was also filed by Hanson, and that was granted on February 23rd, 2006. In the second direct appeal, Hanson raised multiple issues. He raised a confrontation clause issue because by the time of his resentencing, Rashad Barnes had died. And so his prior testimony in the first trial was admitted, because even though his conviction was affirmed, the state still has to prove some of the factual detail of the crime to support its seeking the death penalty. The jury can't decide whether he's guilty of malice murder or felony murder. That's not on the table, but they still need to be presented with the facts of the case, or the facts of the murder, in order to support.
Representing.
Correct.
So it's not really a re-adjudication. It's just presenting the key facts.
Correct. And he argued that admission of that testimony violated his constitutional right to be confronted with the witnesses against him. He argued the testimonial hearsay should have been excluded from his resentencing trial because he did not have a full and fair opportunity to cross-examine Barnes about impeachment evidence that came to light after his original trial. And that was that Miller had confessed to an inmate by the name of Ahmaud Henry, that had told Ahmaud Henry that Barnes and Hanson committed the murders, and that he wasn't involved. And then also that his testimony in his own trial implicating Barnes and Hanson. Oh, no, the confession to, sorry, I got that confused. Miller confessed to Henry that he shot Mary Bowles. At least that's what Henry told Tulsa police in an effort to get some kind of deal on his own criminal charges. And then Miller's trial at his testimony at his trial implicating Barnes and Hanson in the murders. He also argued new evidence that the Court of Criminal Appeals erred in reversing the district court's decision granting him a new trial on Hanson's malice aforethought murder conviction of Bowles based on that newly discovered evidence. He alleged prosecutorial misconduct, that the prosecutor engaged in deliberate misconduct during closing arguments that violated his right to due process and a fair resentencing trial by attempting to distract and inflame the jury by emphasizing the defenseless and sympathetic character of Mary Bowles, asking jurors to imagine Bowles' mental state in her final moments, asking the jury to consider the final moments experienced by Jerald Thurman, and the mental state of the bank teller Hanson robbed, and arguing that since he was serving a life sentence without parole, only a death sentence could serve to redress the murder of Mary Bowles. He also alleged ineffective assistance of trial counsel for failing to adequately prepare an expert witness, failure to call Ahmaud Henry, failure to properly preserve constitutional error, to object to prosecutorial misconduct, and to investigate and present available mitigating evidence. Sorry. He alleged that the aggravating circumstance of knowingly creating a great risk of death to more than one person was not supported by the evidence or Oklahoma law. He alleged that the murder, the aggravating circumstance of the murder being committed to avoid or prevent lawful arrest, that the state was constitutionally barred from alleging this aggravating circumstance because at the resentencing trial, because jurors in his first trial did not find this circumstance. He alleged that the trial court's refusal to give his requested instruction defining life imprisonment without possibility of parole, and his parole ineligibility denied him a fair resentencing trial. He alleged that the mitigating circumstances instruction defining mitigating circumstances, when considered with the prosecutor's closing arguments, improperly limited the jury's consideration of evidence presented in mitigation. And then he also argued, of course, cumulative error, that even if no single error merited reversal, that the cumulative effect of all these errors committed during his resentencing necessitated modification of his death sentence. The decision was rendered on April 13th, 2009. Basically, defendant was convicted of first-degree murder and sentenced to death. His death sentence was vacated but imposed again after the jury found 3 aggravating circumstances. Defendant appealed, but the death sentence was affirmed. A rational jury could have found that the victim was killed because she witnessed the murder of another victim and that defendant killed her to avoid a lawful arrest. Therefore, the aggravator was supported by sufficient evidence. Additionally, the jury's finding that defendant had been previously convicted of felony involving the use or threat of violence, and that he murdered the victim for purposes of avoiding arrest or preventing a lawful arrest or prosecution, was amply supported by the evidence. The appellate court was unable to find, under the circumstances, that discovery of a co-defendant's statement rendered defendant's prior opportunity to cross-examine a former co-worker constitutionally inadequate, or that the trial court erred in admitting the co-worker's testimony via transcript. The appellate court was not convinced that the prosecutor's argument rendered defendant's resentencing trial unfair. And so the judgment, the death sentence, was affirmed.
Do you have a little more information about that, that other, that testimony that he was talking about?
Well, basically, I thought I had addressed it in my notes, and I must have accidentally deleted it when my mouse had a fit. Prior to his arrest, Hanson had been living in a vehicle in Rashad Barnes's backyard. And he told Rashad Barnes basically that he and Miller kidnapped Mary Bowles. Miller killed Jerald Thurman, and Hanson killed Bowles. So in addition to his confession to police, we had that confession to Rashad Barnes. Rashad Barnes testified at trial, the first trial, and then died during the pendency between the direct appeal and the reversal and the resentencing trial. So his full testimony was admitted at the resentencing trial. And what Hanson's attorneys were arguing was that they didn't have the opportunity to cross-examine Barnes with this impeachment evidence consisting of Miller's confession to shooting Bowles to Henry, as well as Miller's testimony implicating Barnes and Hanson in the murder or murders. But that was not found to be sufficient to undermine Barnes's testimony. And that, Miller's testimony implicating Barnes and Hanson doesn't help Hanson. And they also found that they were able to get Miller's statement to the detective. They were able to get Henry's statement to the detective that Miller confessed to shooting Bowles into the trial without calling Henry, who had credibility problems up the wazoo. I mean, he was I think the detective actually testified at trial that Henry was not credible and that he didn't believe Henry. And he thought Henry was just making up things to try and get a deal for himself. So that was the end of his resentencing direct appeal, and his sentence is lawful, basically found by the Oklahoma courts, at least at this stage.
That makes sense.
Hanson did file a petition for rehearing and a motion to recall mandate on May 1st, 2009. That was denied on May 22nd. He filed an application for extension of time to file a writ with the U.S. Supreme Court on August 5th, 2009. That was granted on August 13th. His petition for writ of certiorari was filed on October 19th, 2009. A conference was held by the court on the writ, and an order issued on December 7th, 2009, denying the writ. So on that date, Hanson's convictions and sentences became final. Hanson filed, going back in the state process, a state post-conviction filing was made on May 16, 2002. This was while his direct appeal was pending, I believe. He was given several extensions to file his application, because I think what he did was like initial filing, I'm gonna file post-conviction relief. He was given several extensions of time. He finally filed his actual application and motion for evidentiary hearing on June 9th, 2003. On June 17th, 2003, the Court of Criminal Appeals dismissed that application as mooted by the disposition on direct appeal of his death sentence. Then on June 5th, 2006, he made a second initial filing, and a motion for abeyance was also filed on February 6, 2008, seeking to hold his state post-conviction in abeyance. That was denied on February 28th. He was granted a final extension of time to file his application for post-conviction relief, and that was on March 11th, 2008. On April 16th, 2008, an attorney by the name of Robert W. Jackson appeared on behalf of Hanson. And on June 30th, 2008, his second application for post-conviction relief was filed. Basically, there were 2 or 3 issues raised. The first was that the Court of Criminal Appeals erred in granting the state a writ of prohibition, reversing the district court's decision, overturning his conviction for the death of Mary Bowles, and granting him a new trial based on newly discovered evidence. The second proposition was ineffective assistance of trial and appellate counsel for failure to challenge aggravating circumstance that he murdered Bowles to avoid a lawful arrest or prosecution, on the basis that his jury was not required to unanimously agree on the particular predicate offense which led him to kill Bowles to avoid arrest. And proposition 3 was that the accumulation of error on appeal and in post-conviction requires relief. The state responded on October 7th, 2008. And the Court of Criminal Appeals issued an order on June 2nd, 2009, finding that they had reviewed his application for post-conviction relief and concluded that there existed no controverted, previously unresolved factual issues material to the legality of Hanson's confinement, that Hanson's grounds for review had no merit and or were barred from review, and the Capital Post-Conviction Relief Procedure Act warranted no relief in this case. Accordingly, his application for post-conviction relief is denied. And his motion for evidentiary hearing was also denied. He filed a third application for post-conviction relief. Basically, in 2010, he filed in federal court to appoint counsel to pursue federal habeas corpus relief and to proceed in form of pauperis, which means he doesn't have to pay as he goes in the federal system. He would have to pay, I think, after, or the state would have to pay after proceedings concluded. The order denying those motions was entered on March 1st, 2010. And then attorneys appeared on behalf of Hanson, and a scheduling order was issued. The petition and state record were filed, and then Hanson sought federal court's permission to go back to state court and exhaust a ground for relief, which was granted. So on January 26, 2011, a third application for PCR and motion for evidentiary hearing were filed, alleging ineffective assistance of trial, appellate, and PCR counsel for failure to prevent evidence of mental illness and cognitive dysfunction in mitigation. On March 22nd, 2011, the Oklahoma Court of Criminal Appeals, after reviewing Hanson's second application, concluded that he is not entitled to relief. And basically that is because in connection with this application, evidence was admitted showing that Hanson was evaluated by mental health people through the indigent defense system, who did not find sufficient mental impairment or cognitive dysfunction to warrant further investigation. And that decision was not made by attorneys. It was made by mental health professionals employed through OIDS.
Yeah, and that's always hard, right? Because anybody that's gonna kidnap an old lady and shoot her in a dirt pit has got to be mentally impaired.
Well, no. They
Well, I
could
know,
just
not
be,
legally.
they
I'm
could
just
just be
saying. I
plain
mean,
evil.
yeah, you're definitely something's not right. All the wires are not connected properly.
Yeah. I don't. That's a personality disorder. Personality disorder is not mental illness.
No, yeah, agreed. Yeah, I'm not saying
a personality
legally
disorder. You understand that your conduct is wrong.
Oh yeah,
you
I
understand
absolutely know it's wrong.
What you're doing is bad, and you don't care.
Right, you're just a sociopath.
Yeah, or a psychopath. So they denied relief on his second post-conviction application. So he returns to federal court. The grounds he raised in his writ of habeas corpus were that he was denied an adequate opportunity to confront the witnesses against him by the trial court's admission of testimonial hearsay of Rashad Barnes. Ground 2, that his right to due process was violated by the Oklahoma Court of Criminal Appeals reversal of the district court's grant of a new trial on the basis of newly discovered evidence. Ground 3, that he received ineffective assistance at trial and on appeal, violating his rights under the 6th and 14th Amendments. That his trial was rife with prosecutorial misconduct such that he was denied a fair trial under the 6th, 8th, and 14th Amendments. That invalidation of the great risk of death aggravating circumstance required invalidation of his death sentence. Ground 6, errors involving the murder to avoid lawful arrest or prosecution, aggravating circumstance violated his rights under the 5th, 6th, 8th, and 14th Amendments. The state's failure to allege with specificity the predicate crime for which Mary Bowles' murder was committed in order to avoid arrest or prosecution violated his rights under the 5th, 6th, 8th, and 14th Amendments. Ground 8, that Oklahoma's uniform jury instructions defining mitigating circumstances contain impermissibly limited consideration of mitigation evidence, and moreover, that prosecutors in the case exploited the instruction improperly to deaden or eliminate the jury's consideration of important mitigation evidence in violation of the 6th, 8th, and 14th Amendments. The cumulative effect of errors at both phases of trial deprived Hanson of his constitutional rights under the 8th and 14th Amendments. That was ground 9. And he also filed a motion for discovery and evidentiary hearing. On April 5th, 2011, an order was entered setting and resetting deadlines that had been had basically been not met because the case had gone back to the state court. On June 7th, 2011, an order was filed requiring the state to respond by July 7th, 2011. The state court record was filed at several points during 2011 and 2012. On the state filed its response on August 8th, 2011, after being granted one extension of time, and a reply was ordered by the court on September 29th, 2011 by October 31st, 2011. The court rendered its decision on July 1st, 2013. It concluded that his request for evidentiary hearing and for discovery were denied as not warranted, that basically the record was sufficient for the federal court to review and make its determinations. After careful review of the record in this case, the court concludes that petitioner has not established that he is in custody in violation of the Constitution or laws of the United States. His petition for writ of habeas corpus shall be denied. Hanson was granted a certificate of appealability on grounds 3 and part of ground 7, insofar as each raises an issue of ineffective assistance of trial or appellate counsel. So the petition for writ of habeas corpus was denied. Certificate of appealability was granted on 2 grounds, and a separate judgment was entered in the matter denying relief. He filed a notice of appeal on August 13th, 2013 at 10th Circuit. On July 30th, 2015, the 10th Circuit affirmed the denial of relief. Their mandate issued on October 8th, 2015. He filed an application for extension of time with the U.S. Supreme Court on December 14th, 2015. That was granted on the 17th. On February 26, 2016, he filed his petition for a writ of certiorari. Conference was held on that petition on May 12th, 2016, and on May 16th, 2016, his writ was denied. Hanson filed a 4th application for post-conviction relief and a motion for evidentiary hearing on September 8, 2020, arguing that the state did not have jurisdiction to prosecute and punish him in this case because he was a member of an Indian nation and the crime occurred on Indian territory. On April 2nd, 2021, the Court of Criminal Appeals granted a motion for evidentiary hearing and remanded the case to the District Court of Tulsa County to take evidence and make conclusions concerning Hanson's Indian status and the location of his crimes based on McGirt versus Oklahoma, which was a Supreme Court case decided in 2020. And we talked about that with Benjamin Cole.
Yeah, I was like, I remember the McGirt decision and Cole.
Yeah. So the findings of fact, however, in Hanson's case did not go as well for him as they went for Cole. On July 2nd, 2021, the court entered findings of fact that found basically that Hanson had failed to meet the two-part test set out by the OCCA in a case called Bossy. And in its order of remand, the court concluded that Hanson was not an Indian for purposes of the MCA at the time of his crimes because he did not seek admission to the Indian nation until 20 years post-offense. And consequently, the MCA does not apply in this case, and the state has jurisdiction over Hanson's crimes. A motion to continue stay of proceedings was filed by Hanson on September 7th, 2021, based on a party's intent to pursue appeal of the OCCA decision in Matloff, which was another MCA case where I think that was where the OCCA determined that McGirt is not to be retroactively applied to state cases that are final at the time that were final at the time McGirt was decided. And my apologies to listeners for not looking that up to ensure that that is correct. The stay was denied on September 9th, 2021. And on September 9th, they issued a decision that basically found that Hanson's state convictions were long final when McGirt was decided. His case is controlled by the decision in Matloff, and he is not entitled post-conviction relief based upon this jurisdictional challenge. Motion to recall the mandate was filed on September 10th, 2021, again, basing it on one party's intent to appeal Matloff to the U.S. Supreme Court. That motion to recall mandate was denied because Matloff was a final decision of the Oklahoma Court of Criminal Appeals, and that was on September 20th. He filed a petition for writ of certiorari on November 22nd, 2021, which is ironic because of his name. It's the anniversary of President Kennedy's assassination. And the case was, conference was held on February 18th, 2022, and on the 22nd of February, the writ was denied.
Speaking of dates, February 18th is my sainted mother's birthday.
Oh, how wonderful.
We've actually had a couple of applicable dates. There was the 9/14, which is my anniversary, which was another, I didn't mention it earlier. So this is a lot of dates in this case line up with my life.
That is also my birthday.
Yeah, I think I remember that from Facebook.
Yeah, so all right. So now once the this issue is resolved with the fourth or third, because I think they're not counting the first one because it was dismissed as moot, post-conviction relief application. The as we recall from our other Oklahoma execution cases, in 2014 and 2015, executions could not be performed or carried out in Oklahoma because of the investigation into the execution of Clayton Lockett, the error that occurred during the execution of Charles Warner, the challenges by Richard Glossop and other inmates to the Oklahoma lethal injection procedure, using midazolam as the first drug for sedation. So that was all held up until a new procedure was enacted, I believe in 2020 or 2021. And I don't have that date on there because Hanson was not actually one of the inmates even directly involved in any of this, because He didn't have an execution date during 2014 or 2015. He did become a party to the challenge in federal court to the new procedure, but he wasn't a challenge. He didn't have a challenge
He didn't participate in the
active
original decision
in the
or
2015
action.
protocol. So on June 6, 2022, that protocol was ruled constitutional by Judge Frio for the who was at the U.S. District Court for the Western District of Oklahoma. The state filed its notice regarding execution dates to seek 25 execution dates over the next 3 years on June 10th. That Hanson's execution date was ordered on July 1st, 2022 for December 15th, 2022. On July 5th, 2022, a clemency hearing was set for November 9th, 2022. On August 4th, 2022, the Tulsa County DA, Stephen Kunzweiler, sent a letter to Warden C. Rivers at USP Pollock requesting that George John Hanson, aka John Fitzgerald Hanson, be transferred from federal custody to state custody for execution pursuant to 18 USC section 3623, paragraph 1, and requesting that transport occur no later than October 1st, 2022. A certified copy of the judgment and sentence for Hanson were attached, and the DA requested that pursuant to 18 USC section 3623, paragraph 3, that he certified that the transfer was in public interest. On September 28, 2022, the acting complex warden, S.R. Grant, on DOJ BOP Bureau of Prison letterhead, sent a letter to Kunzweiler advising that the Designation and Sentence Computation Center had denied the state's request for transfer of Hanson for execution of a sentence in the state murder case as not in the public's best interest. Then on October 14th, 2022, AG John O'Connor sent a letter to Heriberto Tellez, the regional director of the South Central Regional Office, requesting Hanson's transfer from U.S. Bureau of Prisons to state custody. O'Connor made the request as executive authority in the state responsible for law enforcement and submitted the request pursuant to 18 USC section 3623 and Bureau of Prison policies. He included a certified copy of the judgment of sentence and advised that the transfer was necessary because the Oklahoma Court of Criminal Appeals had ordered Hanson's state execution sentence be carried out on December 15th, 2022. He also advised of the clemency hearing set for November 9th, 2022. On October 17, 2022, Rennie Noel, on behalf of Tellez, sent a letter to O'Connor, also on Department of Justice, Bureau of Prisons letterhead, advising that Hanson is in the primary jurisdiction of federal authorities and that I am unaware of any indication another sovereign may properly possess primary jurisdiction of him. On June 28, 2000, the Honorable H. Dale Cook, United States District Judge for the Northern District of Oklahoma, sentenced Hanson to a term of life imprisonment, which he has been serving since that date. As inmate Hanson is presently subject to a life term imposed in federal court, his transfer to state authorities for state execution is not in the public interest. And it is that has ended up with a lawsuit in federal court seeking transfer of Hanson to state authorities for execution. And I just want to I just want to pause for a moment to say what a group of ridiculous assholes are at the Bureau of Prisons. They are basically collaterally attacking a state conviction and sentence to promote the current administration's stance on the death penalty. And that's all this is. And I have a feeling that we're going to find out that Mr. Tellez does not have the oomph necessary to ultimately succeed in this stance. So he's going to end up looking stupid.
Well, and that just runs counter to our, general system of government, because generally the state should have primacy in most, anytime there's a contradiction, the state should be given primacy. That's our whole federalist system.
Yep. Well, and it's actually they're joint, they're separate sovereigns and they have equal rights. And so if Hanson had been in state custody and the feds had said, well, we want to try him for the bank robbery, transfer him to federal authority so we can try him for the bank robbery. And the state had said, no, we got him on capital murder. You don't need to try him on bank robbery. They would lose. Because they can't say, no, we have him on capital murder. We're not trying him. We're not letting you try him. So anyway, so this is, the case is State of Oklahoma et al. Versus Tellez et al. It's filed in the Northern District of Texas, the Wichita Falls Division. And if anybody wants to look it up, it's docket number 7:22-CV-00108-0. Counsel for the state of Oklahoma, the plaintiff or petitioner, is John Clay Sullivan, Greg Cleveland, and William Flanagan. The Bureau of Prisons is represented by Brian C. Rosenshaw, and that's Shaud, and I've known people who pronounce it show. Brian Walter Stoltz, who's with the Department of Justice, Joseph John DeMott, and Michael James Gaffney. It's again, it's in the United States District Court, Northern District of Texas, Wichita Falls Division, and the judge is the Honorable Judge Reed C. O'Connor.
And no at the end, this is just about the Bureau of Prisons basically seeking to prevent the state of Oklahoma from carrying out its justifiable sentence.
Correct. And a complaint
legally and ethically determined.
It has been determined by federal court to be a lawful conviction and sentence. It's been determined in state court to also be a lawful conviction and sentence. So the federal executive officials have no legitimate reason to question.
Right. Well, it's a very dangerous precedent, because it continues to show kind of how the federal bureaucracy or administrative branch just continues to get more authoritarian and over trying to overturn the will of the people, which is best represented by state governments and local governments, and just try to suppress the will of the people by their authoritarian opinions. It's a very, very dangerous precedent.
Yes. So, and I'm going to go over the complaint for declaratory judgment is the first thing, and they also requested a writ of habeas corpus, which isn't just for prisoners. It was filed by the state of Oklahoma, John M. O'Connor and Steve Kunzweiler, against Tellez, who's regional director for Texas, Oklahoma, and Louisiana, and he's located in Grand Prairie, Texas, which is in the Northern District of Texas. Colette S. Peters, who's the director of BOP, S.R. Grant, the acting complex warden at FCC Pollock, and the Bureau of Prisons, arguing or alleging that unelected officials of the BOP lack discretion to refuse to transfer an inmate to state custody based on their denial that the enforcement of a state death sentence is not in the public interest. Congress is yeah.
What was this gonna say? I mean, people need to realize, because people can get very tribal and like, oh, well, I oppose the death penalty, so this is a good thing. It's not. Regardless of your opinion on the death penalty, this is extremely authoritarian. If you oppose the death penalty, you can lobby the state of Oklahoma and you can get it overturned. It doesn't, your opinion of the death penalty should not matter in your opinion of this case, because this is massive federal overreach and very authoritarian and very concerning for anybody that believes in liberty and democracy and the will of the people.
Correct. And hopefully the federal court is going to put smackdown on that. So they also argued that Congress had enacted the transfer statute, which addresses transfers, mandating that the Bureau of Prisons shall order the transfer of a federal inmate to state custody when state officials comply with certain procedures and the transfer is in the public interest. They also argued that public interest favors timely enforcement of the death penalty at both the state and federal levels. They argued that they believe the transfer statute has meaning, that the public interest requires transfer here, and that the executive officers sued have retained custody of Hanson in violation of the laws of the United States and have acted ultra vires, which is acting or done beyond one's legal power or authority, in denying the transfer. They argued that Hanson had exhausted all of his appeals and post-conviction remedies in state and federal court from his Oklahoma convictions, including denial of certiorari by the U.S. Supreme Court, that he had unsuccessfully challenged Oklahoma's execution protocol and method of execution, that the Oklahoma Court of Criminal Appeals had scheduled his execution on July 1st, 2022, and that public interest favors timely enforcement of a properly imposed and federally confirmed death sentence, and that public interest disfavors delay. They also argued that delay defeats public interest in retributive justice and deterrence that underpin the use of the death penalty, which is from Gregg versus Georgia, 1976 case from the Supreme Court, which reinstated the death penalty in the United States. They argued the public has a compelling interest in timely enforcement of the death penalty to prevent harm to families and communities of the victims from undue delay. And after direct appeal and post-conviction remedies are exhausted, any de facto commutation of a death sentence to life imprisonment outside of the proper state executive branch authority is indisputably contrary to the public interest because of the profound injury it inflicts on the public interest. So they're seeking a writ of habeas corpus, which basically would order the transfer of Hanson from federal custody to state custody. They also order a finding that the executive officials have acted outside their authority, and they seek declaratory relief, which is that they're entitled to the transfer of Hanson to state custody under 3623.
And that seems to be a continued theme we see today as federal officials exercising way outside of their authority and continue to be more and more authoritarian.
And, you know, I mean, if that's the administration's stance on the death penalty, then they don't have to set federal executions.
Exactly.
And frankly, if President Biden wants to commute every federal death sentence, he probably could do that.
Well, and
although notice that he hasn't done it.
Right. Well, and I'll say, I've never stated my personal opinion on the death penalty, because I always believe my personal opinion of the death penalty is subject to my personal opinion about the law. And regardless of how I feel about it, if it is the law is the most important thing. So one's own opinion about the death penalty or any other thing should not undermine the will of the people.
Yeah. I don't often express my opinion. Although I will say I feel that it is a just and necessary punishment for certain offenders who have committed certain crimes. And while I may not always agree when a person I believe should face death doesn't get it, I respect that on an individual basis, that jury at that time found that they should be merciful.
Right.
And
Yeah.
I'm talking about Nicholas
Yeah.
Cruz, the shooter, the Parkland shooter in Florida.
Right. And sometimes your allegiance to the system and just everything, like the bigger picture is more important than a particular issue.
Yeah. But that is, that's my opinion, and it's not really worth more than about 11 cents. So, but yeah, I don't think that the Bureau of Prisons, and like I said, this is probably not going to work out well for them. The question is how much the media is going to cover.
Right. Well, and that's
how
my
the media is going to spin it.
That's my biggest concern. It's like, independent of my personal opinion of the death penalty, I am extremely concerned by some bureaucrat in the Bureau of Prisons effectively overturning an entire state's jurisprudence. Like that's a big problem. That's a much bigger problem than one individual death penalty case.
Yeah. So, so the prayer for relief by the state of Oklahoma and A.G. O'Connor and D.A. Kunzweiler is a writ of habeas corpus requiring the surrender of Hanson to Oklahoma state authorities, a preliminary and permanent injunction enjoining defendants from violating 18 U.S.C. Section 3623, a declaration that defendants have unlawfully refused to transfer inmate Hanson to state custody under 3623, and an accompanying order that defendants do so before November 9th, 2022, a judgment for costs as appropriate under 28 U.S.C. 2412, and such other relief as the court may deem just and proper. Now, the preliminary and permanent injunction would be what would prevent BOP from doing this down the road should another state such as Texas or Alabama or Ohio, although Ohio hasn't really executed anybody in years, seek transfer of a federal inmate to state custody for execution. So this is going to have long-reaching implications if the judge rules in favor of the state of Oklahoma. They also, like I said, filed a motion for writ of habeas corpus or temporary restraining order. They're brief in support of habeas corpus. There are a lot of similar statements and arguments as those made in the original petition for declaratory judgment. So I'm not going to go into all those again, although I will mention one that Tellez's reasoning that he will not transfer custody because he has primary jurisdiction is impermissibly circular, and that's because primary jurisdiction can change. If they transferred him to Oklahoma, Oklahoma would then have primary jurisdiction. And I think the biggest takeaway from this is that what Oklahoma is arguing is that, contrary to their mistaken belief, they don't have authority to violate the federal transfer statute because they don't think the death penalty is a good thing. Also, they also made the allegation that they're playing games, and they kind of sort of are, because the court could not rule on the request made by Oklahoma before November 9th. Just basically because the procedure and the federal, the Bureau of Prisons raised jurisdictional issues and venue issues, and they basically argued that that habeas authority actually rested with the Western District of Louisiana, which has currently been inundated with Hurricane Laura, Hurricane Delta claims. So their reduced judiciary manpower is sorely tested right now. As someone who filed a case in the Western District of Louisiana recently and had to wait almost a week for the clerk's office to process that case, assign a judge, assign the division, and finish the administrative process for that case. They also argue that 3623 imposes no constraints on the federal executive branch, and they falsely stated that Tellez did not reference the death penalty in his denial, which is untrue, because I quoted exactly what Tellez said. So then the Oklahoma has replied to Tellez's response. They also filed a response in opposition to the motion to transfer to the Western District of Louisiana, or they also are seeking transfer to the Dallas division of the Northern District of Texas, because that's where Tellez is located in Grand Prairie, Texas, which is outside Dallas.
It's basically a next door suburb.
So they basically found that the motion to transfer, they argued that the motion to transfer is based on factual inaccuracies and wrong assumptions, that the BOP entities who processed and rejected the transfer request were in the Northern District of Texas. Tellez is in the Northern District of Texas. So for counts 1 and 2, for 2 and 3, venue does exist in the Northern District of Texas. They pointed out the divisional venue was abolished in 1988, and the question of divisions within a district are a matter of convenience for the parties, absent local rules requiring otherwise. They argue that Wichita Falls is the most convenient division for plaintiffs coming from Oklahoma. That this was an interesting quote, and I really liked it. Defendants fail to acknowledge the geographical, logistical, and legal sense it makes for Oklahoma state officials to sue in the most relevant district, most relevant division where the admitted decision makers reside, or district where the decision makers reside, and in the most convenient division in that district for the Oklahoma officials. They also said, in defendants' view, the public interest is violated when plaintiffs choose a proper and convenient forum for their lawsuit near defendants, but not when a murder of an elderly woman escapes a validly bestowed punishment. That contrast speaks volumes. On November 3rd,
That's a great quote.
The Bureau of Prisons filed an intent to file a reply brief supporting their motion to transfer, which was filed, and they basically argued that Wichita Falls Division is not a convenient forum for any of the parties or witnesses, even though it is convenient for the Oklahoma authorities coming from Oklahoma. And they argue that the case should be transferred either to Western District of Louisiana or the Dallas Division of Northern District of Texas. And the court has not ruled on any of this yet. And I think basically it was impossible for them to do so in the time they had, because this wasn't filed until October 25th and couldn't have been filed because the Bureau of Prisons didn't officially deny the request until October 14th. So it was filed as soon after. It could have theoretically been filed at the beginning of October, but it would have probably been considered premature because that was based on the warden, not the Bureau of Prisons denial. So it's kind of a toss-up. So on November 8th, the Pardon and Parole Board canceled the clemency hearing because Hanson's not in state custody. And his execution, because he's not in state custody by the 10th of November, he can't begin the 35-day process required under the protocol. And so his execution likely could not go forward on December 15th. So what's going to happen now is the federal court in Texas is going to first decide whether it has jurisdiction or not. If it decides it doesn't have jurisdiction, it's going to transfer either to the Western District of Louisiana or to the Dallas Division. If it decides, if the judge decides he has jurisdiction, he will render a decision that will be appealable to the Fifth Circuit Court of Appeals.
Hey, Lisa, you probably mentioned this earlier. I think you did, but why did it end up in the Wichita Falls division?
That is the most convenient for the Oklahoma entities coming from Oklahoma. That's the closest division.
Aren't they in Tulsa?
They're in Tulsa. The Northern District of Texas, Wichita Falls, is closer geographically and logistically than Dallas.
Okay, I might have a little bit of, I might have a little, yeah, no, for Tulsa, I might have a little bit of I might gripe with that, but okay, fair enough.
Well, what do you mean?
Well, I mean, because, Wichita Falls is west, right? So it's like 3 or 4 hours west of Dallas, and, Tulsa is east of Dallas. So you're talking about going all the way across the state, whereas Dallas is Oklahoma straight down
of Dallas.
But slightly north.
Okay.
But more west.
Well, I don't know.
Yeah, fair enough.
I just, they have determined that it is probably distance time closer to them than Dallas. It may be that jog south. It may be that there's a highway directly between Tulsa and Wichita Falls, whereas Dallas, they'd have to, I don't know. Maybe they don't want to deal with I-10 or whatever the interstate is in Dallas.
No, fair enough. Traffic can be bad.
I don't know, but they're arguing Wichita Falls is the closer, and it's certainly in a hardship from Grand Prairie to Wichita Falls. Correct?
Wait, sorry. Say that again.
Traveling from Grand Prairie to Wichita Falls would not promote a hardship.
No, not at all.
For Tellez and the
absolutely not.
Yeah. Okay. So anyway, that's their argument. And they may have also chosen the Wichita Falls division has fewer cases. So something that's time sensitive is probably going to be more quickly decided in Wichita Falls than in Dallas. Certainly than in Western District of Louisiana.
Okay, I will be accountable because I just looked on Google Maps, and according to Google Maps, I will own it. Wichita Falls is closer to Tulsa than Dallas. I never would have believed it, but nope, that is correct. So I stand corrected.
That's okay. That's all right, Kyle. That's all right. It was good of you to question. And it was good of you to admit that,
And looking on
from
the
a
map,
strictly mileage.
Wichita Falls is more north than I realized. So
Okay.
it is a little bit more north than I thought.
Yeah. Because I thought Wichita Falls was in that panhandle of Texas that sticks up.
No, it's not in the panhandle. That's Amarillo, but
Oh, okay.
it is quite a bit far north. Cause like, I guess Dallas is maybe hour and a half from the Oklahoma borders, and Wichita Falls is on the border. So it's basically an hour.
Oh, okay. Yeah. See?
So it's basically on the border.
Okay. So, all right. So that is Hanson's in limbo. My expectation is that the Oklahoma authorities will wait until the controversy has been resolved and Hanson is in state custody, and then they'll probably seek to vacate the December date and have a new date ordered by the Oklahoma Court of Criminal Appeals once they have Hanson in custody. And I think that they're pretty assured of success, because the reasons for denying the transfer are not valid under 3623. They don't have the discretion under 3623 that they seem to think that they have, because they are trying to stay in line with the administration's stance against the death penalty.
No, I think you're right on that. It's spot on.
So, all right. Well, we have a few quick updates that I wanted to get in today, because a lot's been going on in Oklahoma. And of course, people have probably heard Governor Stitt has been reelected. The 10th Circuit Court of Appeal on October 19th, 2022, affirmed the Oklahoma execution protocol, that it does not violate the U.S. Constitution or federal law. So the Oklahoma execution protocol currently is still good. The inmates may file a writ with the U.S. Supreme Court, but they haven't done so yet. They have 90 days, I think, to do so.
Still amazing to me that, the Constitution was ratified when drawing and quartering and burning at the stake was common, and we think that the wrong drug is cruel and unusual.
And they're because they're alleging that midazolam doesn't do the job to make you insensate.
Yeah, it's like we were talking about when the guillotine was thought to be not the most humane way to execute.
Yeah. Benjamin Cole was executed on October 20th, 2022, and there were no complications. While his attorneys continued to tell the media that he was, too mentally incompetent and didn't communicate. He did communicate with the state doctors when they challenged his competency, and he did make a final statement. It was a bit odd, but Benjamin Cole was an odd duck.
It looked like he was trying to beat Damien Eccles with that crazy beard.
Now, I think he had it from the time he had it before Eccles.
That's probably true. Yeah. Damien Eccles was probably trying to be Benjamin Cole.
Yeah.
Because Damien Eccles is always trying to be somebody else. That guy hadn't had original thought in his life.
I think it's also funny that his attorneys claim that he didn't know why he was being executed, and yet he told the doctors back in July he was being executed for murdering his daughter.
I don't mean to laugh, but that's the best part is these excuses of these criminals. They're like, and I have no idea why, but I just told somebody exactly why.
I think that his reticence to communicate with the attorneys was because they were calling him crazy. and he wasn't crazy. So, then on November 2nd, 2022, Governor Stitt granted Richard Glossop a second reprieve, moving his execution date to February 16th, 2023. He did this on the date that Glossop would have begun the 35-day pre-execution process. So perhaps he was convinced to do so to save Glossop from going through that again, because Glossop had been through the process with his prior execution dates. I really don't, I don't know what led Stitt. I was told by someone that Stitt doesn't have the authority to grant a second reprieve, but the AG did not challenge it. And so he's letting it stand. Stitt claimed he did that so that the Court of Criminal Appeals could fully review Glossop's 2 post-conviction applications for relief. On November 10th, the Court of Criminal Appeals denied the first application and request for evidentiary hearing that were filed in July of 2022. The second application and motion for discovery and evidentiary hearing are pending, but more likely than not will be decided very soon. Hopefully before Stitt can grant another reprieve. Glossop's clemency hearing was also postponed. And we'll look at the order denying relief in more depth when I look at Glossop's case after the second order is issued. Because I don't want to go through all of that and then have another thing hanging out there. So once the second order comes out and he's, this date of February 16th looks like it's going to go, we'll talk about
Right.
Glossop again.
Yeah, that makes a lot of sense. No sense in wasting a bunch of time on
And,
details that aren't going to be germane.
And it'll only be these 2022 applications, because we've talked about the 2015 application and we've talked about some of the Reed Smith bullshit and how it's nothing but what Don Knight had in 2015 that Reed Smith just, put a freaking bow on a pig.
Yeah,
to try and bring it within the 60 days.
I mean, that was some of your best work. I mean, you did a remarkable takedown of all of it, very, very much detail of Reed Smith's propaganda.
Thank you.
You did an amazing job.
Well, hopefully I'll do the same with the 2022 post-conviction writs applications. And then finally, Richard Fairchild, who we talked about on October 16th-ish in episode 17. He is still due to be executed on November 17th, which is this Thursday. As everybody will recall, clemency was denied. And his execution is scheduled to proceed on Thursday. And I have found no attempts to block that execution by attorneys on his behalf. I haven't found anything.
No, yeah, I did the same thing. I did a search to look to see all the updates on these cases, and I did not find anything on his case in terms
I found
of trying to stop
nothing in state court, nothing in federal court. I know there was an allegation that he was not competent to be executed, but it does not appear that any legal proceedings have been filed for a competency determination or a competency trial. And the time to do that is gone. So
Well, they may have gotten a little common sense too. If of all the hills we're going to die on, this is not one, because this guy's obviously a monster.
So, well, I'm a little surprised, but I didn't find anything in Pittsburgh County seeking a competency trial. But I will, if I'll keep looking, and they may wait and file that Monday because it can't possibly be resolved by Thursday. and that would result
You
in
always
the
have the
need
last
for a
minute.
stay of execution. So, but we'll see. We'll have to see. So any final thoughts?
I mean, I think, I'm going to repeat myself, but I just think this is an interesting case. And I think it's sometimes important to keep the bigger picture in mind, which is our particular opinions about an issue really need to be secondary to the bigger, governmental legal issues at stake. And that's why these cases are so important, because regardless of what we think about the death penalty, the bigger issue is the federal government's power and trying to take more power away from the states, which is very concerning.
And the same applies if the feds wanted to, say the feds had evidence that Rodney Reed committed a bank robbery and the statute hadn't expired and they could try him now and they wanted him transferred to federal custody to do so. State of Texas can't just say no. I mean, the state
Right.
of Texas should allow the feds to charge him and try him if they want to.
Right. And
And
what
should
people
not be a
forget,
roadblock to that.
yeah. And what people forget is once you give away that sovereignty, you
Mhm.
may have liked that you gave away that sovereignty because you like this issue, but tomorrow you're going to disagree with the federal government on another issue, and you've already given away your freedom.
Correct.
So you have to die on that hill. Regardless of the specifics, you have to like the power needs to be with the people and not with the federal government and not the
Mhm.
central authoritarians.
Correct. And like I said, I think that I think the Bureau of Prisons has really bitten off way more than they can chew, and it's gonna result in a decision that's gonna have long-reaching consequences for future Bureau of Prison directors and officers. And so where they might have left some wiggle room for themselves, they're going to end up completely cutting that off.
Yeah, this guy seemed like a fool just trying to get a promotion. Like, what are you trying to do? Be the head of like the Southwest prisons? I mean, this guy just seemed like an idiot.
Well, like I
He
said,
was trying to read the tea leaves and just
he's
like make a dumb decision.
he's trying to go, and probably perhaps some self-preservation was involved, because if the administration stance, and he's part of the executive branch, which is headed by the president, maybe he's just, because that's their stance on the death penalty, he's like, okay, well, I'm going to be a good team player and I'm going to prevent a federal inmate from being executed by a state. And it's interesting, in one of their responses, they argued about the prior protocol and errors with Warner and Lockett that have nothing to do with the current protocol or executions that have been carried out under that protocol going back to 2021 without incident. So they're using the rhetoric rather than following the law, and
Well,
that
and
never ends
not to
well.
go off, not to take away too, but isn't that the problem with our system and our government today? Is it's more about people using the rhetoric and the t-shirts and the slogans and not following the law.
I totally agree. And
I feel like this case sums up a lot of the problems with our system right now in 2022.
Yes, and I'll go one step further. It's getting really sad that people who are on different sides of the aisle can't even talk about the issues without resorting to insults, demeaning, circular logic, and ad hominem. And it's ridiculous.
Yeah, absolutely.
people when the Supreme Court, all the Supreme Court did in overturning Roe was returned the right of states to regulate what is medical procedure as they see fit.
Yeah, I mean, that's a great example, because I will say, I'm not going to mention my personal opinion on abortion,
Well,
but I'm a federalist. I believe that democracy is best served by power closer to the people. So the more things that are decided at the local level and the state level is better. So regardless how I feel about abortion, it should be a state issue.
Correct.
And that's why it's like my principle is more important than how I feel about a particular issue.
Correct. And what I don't like, first of all, I don't like people who claim that we're going to become the Handmaid's Tale, because obviously you don't understand what the Handmaid's Tale was. But also the fact that abortion being described as a right is just distasteful for me.
Well, and I mean, even pro-abortion legal scholars will tell you Roe was a terrible, like, there's no serious legal scholar that will say Roe was a good decision. They literally just made stuff up out of whole cloth.
Correct. And it's not healthcare either. It is a procedure that terminates a pregnancy, and there are a variety of reasons for that to be, that procedure to be required. Now, I do understand that in some states, people are having knee-jerk reactions, such as pharmacies are having knee-jerk reactions. And there have been stories about women, for example, menopausal women, who have been prescribed a medication for an upcoming medical procedure related to menopause that the pharmacist will not fill because it could also be used to induce an abortion or induce a miscarriage, rather. But again, that's something that the individual states and the individual legislators need to deal with.
Right.
If that's happening, then they need to change the law to say if the woman is in menopause, then this law doesn't apply to anybody, her or her doctor or her pharmacist.
Well,
because
and I wonder sometimes too, how much of that is
propaganda.
Well, yeah. Or how much of that is pharmacists or doctors who know that they are fine prescribing it, but they're refusing just to make a stand and to kind of cosplay.
Yeah.
I would like to see the name of a pharmacist or a physician ever arrested or questioned for prescribing a medication to a menopausal woman. Like, just show me that evidence. Otherwise, I don't believe you, because we live in a world of such fake news. I mean, we live in the world of the Russian hoax and Juicy Smalls, who claimed he got attacked by MAGA supporters at Chicago at 2 a.m. with the Subway sandwich. Like, just show. I need to see the receipts, or I don't believe.
Yeah. And his actual attackers ended up being immigrants from Africa.
Yeah, his gay lovers. Like, so I don't believe you if I don't see the receipts. I need to see the receipts, or I don't believe these accusations. I'm sorry. Yeah. You've created this world where I don't believe you.
So I totally agree. But it's sad because, back in the day, Bill Clinton and George Bush, both older and younger, could be friends and enjoy each other's company and look at how they were the same. They were members of the former president's club.
Well, absolutely. And I think it's the situation where you talk about the Supreme Court where, you know, Ruth Ginsburg and Antonin Scalia could be really good friends and they could go on vacation together and they could really enjoy each other's company. And they were both super smart and they intellectually stimulated one another. They
Yeah,
might have disagreed, but they enjoyed each other's company.
correct.
But today it's like, oh no, you're a, you're a
Yeah,
whatever.
yeah. And I've been
You can't
accused
enjoy
of
that.
doing that because people don't agree with me or or I disagree with them, but that's not, I don't resort to ad hominem unless if you give it to me, I'm going to give it back to you.
Yeah, absolutely.
And perhaps that's not exactly right, but and call me fat and ugly. I really don't care, you know,
Well,
but
it's usually
that's
one
pretty
side of
sad
the
that
it's
that's all
usually
you've
one
got.
side of the aisle that starts the personal attacks and the if you don't agree with
Well,
me, you're a
I
Nazi.
don't know because Trump got a lot of bad press when he went after Rosie O'Donnell because he went after Rosie O'Donnell on a personal level that was really inappropriate. And that was years ago before he was even president, before he was even running for president.
Right. Yeah. I
It
don't think
was
it's
kind of like
yeah.
schoolyard bullying. And that's been his MO for many, many years. I've always said when he ran for president, somebody should have taken him and every time he said something inappropriate, smacked him upside the head and said, Donald, stop doing that. And he should never have been allowed on social media. They should have put nanny monitors on all of his computers that would not let him go to Twitter or Facebook or any other social media site and post without a minder.
Well, I was naive enough to think, okay, the office will overwhelm him and he will grow up and act like an adult.
No.
Oops, I was wrong. But I thought that I at least said, well, okay, well, maybe, okay, if we have him, at least maybe the office will overwhelm him and he will grow up. But yeah,
No.
oops.
And it's funny because many, many, many years ago when Mr. Biden was just the senator from Delaware, there was something in the news. He had a medical issue and had a CAT scan or MRI, and he had a brain tumor. And many, many people in Delaware said that's impossible because he doesn't have a brain. You have to have a brain to have a tumor. So, he has been on the receiving end of some pretty unkind things, and that's human nature. We can be unkind. But I think I try to be better. And I try to tell you why your opinion is wrong, dumb, bad. But I don't mean to say you are. I just say your opinion
Right.
is.
Well, and that's the thing that like I enjoy, like I don't really enjoy talking to people. I mean, socialize notwithstanding, but like talking to people that agree with me, that's not fun. Like, okay, great, you agree with me. Okay, cool.
Yeah.
It's actually a lot of fun to talk to smart, thoughtful people that disagree with me because I may learn something. And I'm the first one to say, hey, if you can convince me that I'm wrong, awesome. I'll change my point of view. Cool. I really miss that. I miss people's ability to engage, with diversity and, diversity of thought and people that will disagree with them and really have those conversations because that's how we sharpen the saw. That's how we get smarter. That's how we make better decisions as a culture.
But I think now it's kind of like propaganda is the way they want it to be, and they want to shout down anybody who doesn't agree with them.
Yeah, exactly.
And that's true on both sides of the aisle. It's not just, I'm not saying Democrats do it exclusively. Republicans aren't the ones exclusively. I mean, you have people that if you don't agree with them, then, you're stupid.
Yeah, exactly. Or you're stupid, or you're some kind of ist, or you're something.
Or a
There's something
fascist or
else evil
whatever.
there. Yeah.
And I have some people say things that I find incredibly funny, like saying, I don't believe in the vaccines. It's like, it's not Santa Claus or the Easter Bunny, honey. It's a vaccine. You don't believe it works. You don't believe it's a good idea. You believe it could be harmful to you, or you believe it could be harmful to others. Fine, but don't say, I don't believe in the vaccine. Say, I believe it could harm me. And there are cases of, the Johnson & Johnson. Some people had horrible effects from that. So that is supported. But just saying I don't believe in it is not, you can't end it there. There has to be something more than your belief, because it's not Santa Claus. Give me a reason you don't believe. So, and some people, it's just they can't articulate a reason. So they don't, they just leave it at that. So, all right. Well, I think that's about it. I think we've covered it. We've strayed off the beaten path of true
We only
crime
chased a
into
few rabbits.
politics.
We're just yeah, we only chased a few Bugs Bunnies.
And I have to, I mean, I have to say, I've said this before. I am the product of a mixed marriage. My father was a Republican and my mother was a Democrat, and they never talked politics because they could not talk politics without hurt feelings and raised voices. So I grew up never knowing which side of the aisle either one of them was on.
Well, I will say I'm a product of good old East Texas yellow dog Democrats, which is, if anybody knows what that means, it's, I don't care if they nominate a yellow dog, I'm voting Democrat.
Right. And I was Democrat for a long time. And then Nancy Pelosi put me off being a Democrat because she basically, when the bank failures happened in like 2008, right after Barack Obama was elected, she said that was George W. Bush's fault. And I knew for a fact that it was actually Bill Clinton's fault, because Bill Clinton is the person who enacted the laws that relaxed regulations and made it easier for subprime lenders and those people to make money. And it was those that made, Bernie Madoff's and different banks become personal piggy banks for their owners and the directors.
And thinking people will remember, you can actually see George W. Bush on video in a speech talking about his concern about the deregulation and the kind of Wild West of the loans. And he actually warned us that this was going to be a big problem if we didn't do anything about it. And of course, no one paid attention.
Right.
But I think, Nancy Pelosi is a good example, right? Because I feel like, generally speaking, if anybody goes into Congress middle class, but comes out a multi-millionaire, it's probably a problem.
Yeah. And with Nancy Pelosi,
her husband has made more money on, stock trades right after congressional actions than anybody. So that speaks volumes.
And Nancy Pelosi is just her, the way she is, she began that wave of propaganda and, it's our way or the highway. And there's no room for debate or discussion. And that, bold-faced lie was the first thing that turned me off. Because instead of saying, it's a lot of problems, maybe Bush's administration should have perhaps tried to tighten regulations back up and didn't. Of course, it may have been difficult because I think he was dealing with a Democrat-controlled House that wanted to keep the regulations as loosey-goosey as they could. But I could be wrong. So and people don't often remember too that the root of the problems isn't so much the presidential administration as it is Congress, because it's the makeup of the House and the Senate that enact these laws. The administration simply tries to steer the direction, but they don't even really have final say. They can refuse to sign a law and Congress can go behind them and override their veto. So, Congress is really the one that's responsible when
Exactly.
the country becomes a shit show.
Yeah, the president's just largely a figurehead. It's all
Yeah.
about the Congress.
A lot like the sovereign in the United Kingdom.
Yeah,
Monarch
exactly.
is, she's not ultimately, and now he's not ultimately responsible. It's Parliament. So, all right, well, that's enough, and I've just proven how little I probably know about politics because I've never been very interested in it. All right, we ready to call it a night?
Yeah, absolutely. Thank you for all your work and your great research, and have a great rest of your week, everybody.
Thank you. Thank you for listening to Based in Fact, a true crime podcast with Lisa O'Brien and Kyle Evans. If you like the show and want to know more, you can find us on Facebook or follow me on Twitter at O'BrienLN. Join us in 3 weeks for episode 19, State of Texas versus Henry Watkins Skinner. In 1995, Skinner was convicted of capital murder and sentenced to death for the December 31st, 1993 murders of Twyla Busby and her sons Randy Busby and Elwyn Kaler in Pampa, Gray County, Texas. Skinner began pursuing DNA testing in the Texas courts in 2009. In 2011, he brought his claims to the United States Supreme Court, resulting in a decision called Skinner versus Switzer. Skinner and the state were able to reach a compromise, and since 2011, Skinner's DNA claims have moved at a glacial pace through the Texas court system. Kyle and I will talk about the evidence linking Skinner to the murders of Twyla and her sons, his DNA claims, the testing and results, and his execution, currently scheduled for September 13th, 2023. Until then, have a great 3 weeks and stay safe. Good night.